Okay, so the second speaker in this panel is Joe Wills, and I should just say Joe Wills, classically a very modest person. He sent me this much too short paragraph of his bio which doesn't do justice to all his achievements, so blame this on him, not on me. He's a lecturer in law at the University of Leicester, and he publishes researches in the areas of animal rights and human rights law. Joe has also recently completed a Leverhulme Research Fellowship exploring the legal status of animals in Britain. Joe, the floor is yours. Thanks for being here.
Thanks, Raphael. I think that's about it, actually. All right. So I'd like to reiterate all the other speakers and really thanking Raphael and Sean for organising this conference, and also to all the other wonderful speakers who've presented so far. It's just so fantastic to be at an in-person conference again, especially amongst fellow travellers who are committed to a more just legal and social order for animals. Now, this presentation is about what I regard as some of the inadequacies of our current language in respect to the unique types of wrongs that humans inflict on other animals, and the role that the law could play in the future in redressing this. And this idea really came about as a result of one of the animal rights coffee mornings that the Cambridge Centre puts on. And in it, Saskia gave a 5-minute presentation of the talk you've just heard, and in it she was keen to stress that the analogy she was drawing between international humanitarian law and animal welfare law isn't premised on a claim that there's a direct analogy between animal exploitation and warfare, but rather that the normative regimes governing both institutions shares a whole bunch of striking features, and these features tell us something important and pretty tragic about the current state of animal law. And Saskia's presentation reminded me of an essay written by Tom Regan, and this essay is entitled Animal Exploitation, the War Analogy. It's an undated essay on his website, but I think it was one of the last things he wrote before he passed in 2016. And in this essay, Regan considers the war analogy to how we treat animals, and he notes that there are lots of striking similarities, but he also highlights the dissimilarities as well. So one example of the dissimilarities Regan gives is that, he says, in warfare, the goal is really to defeat one side and get them to surrender. And he thinks this isn't a feature of animal exploitation. And I actually think we could maybe contest this claim of Regan, but nonetheless, he says, and I quote, "The war analogy does not fit the institutional exploitation of non-humans in every respect, a finding that suggests, to me at least, that the industrial exploitation of non-human animals is probably sui generis. That is to say, unique and one of a kind." And this quote from Regan in turn got me thinking about the problem of representing the various atrocities that we humans inflict on the other species, and the role that the law potentially could play in dealing with this. Now, I should note that this is a really loose bag of ideas. I don't really have any concrete solutions here. These are very much first impression thoughts, so I really look forward to people's comments and criticisms and feedback and suggestions in the Q&A. Okay, part one, the politics of analogy. Now, the politics of analogy that Regan discusses in this essay is the product of a strategy or an outlook of the animal rights movement that we can call the similarities approach. Now, the similarities approach stresses the kind of salient ways that humans and animals are similar to each other. And a sort of entailment of this view is that as animals are similar to us in morally salient ways, it's possible for us to engage in similar types of wrongs towards animals that we engage in relation to other humans. So in this line of thought, we get the term speciesism, for example. coined by Richard Ryder and popularized by Peter Singer. And its function really is to act as a direct comparison to sexism and racism. Just as it's wrong to discriminate on the basis of race or sex, so too the thought goes it's wrong to discriminate merely on the basis of species membership. Now, more controversially, some animal advocates draw comparisons between, for example, industrial animal farming and slavery and the Holocaust. So we see this, for example, in Marjorie Spiegel's book, The Dreaded Comparison, and Charles Patterson's The Eternal Treblinka. And these comparisons aren't just controversial amongst critics of the animal rights movement, but also within the animal rights movement itself. There are certain individuals who object to it on object to those sorts of comparisons on ethical grounds or political grounds, and sometimes tactical or strategic considerations. And I don't want to wade into that debate here, but I'll note that one of the limitations of these comparisons is that they fail to capture the unique wrongs, or perhaps more accurately, the unique combinations of wrongs inflicted on animals by humans. So here are a few examples. Oh, God. First, think about the mass breeding of animals, the mass breeding of farmed animals to experience lives of suffering followed by premature death. Now, as Derrida's noted, in one respect, this is the precise opposite of a genocide, the aim of which is to eradicate a group, whereas animal farming involves bringing as many suffering beings into existence as possible. Likewise, whilst both farmed animals and formerly enslaved persons were legally treated as property and subject to exploitation and denials of freedom, in the slavery context, obviously, slaves weren't bred to be slaughtered in mass and eaten. All right. Another example is the selective breeding and mutilation of animals that's designed to make them weak, docile, and reliant on humans. Now, there are, of course, comparisons here with eugenics, but the practices aren't quite the same either. Right? So when we think about eugenics, one of the ideas motivating it, or the justifications, is to prevent the existence of so-called dependent beings. But of course, when it comes to farmed animals, the goal is to breed as many dependent beings into existence as possible. Another example is dairy farming. Right? Think about the cycle of artificial inseminations, forced pregnancies, child abductions, and forced milking, followed by slaughter. Now, of course, we can again see some parallels here with acts of sexual violence and denials of reproductive autonomy that affect human beings, but really that sort of combination of acts is really, as Reagan would put it, a sui generis practice. And I think that in English at least, and I can't speak to other languages here, we really lack an adequate vocabulary to capture the sort of unique nature of these atrocities. And I think this highlights one of the limitations of a similarities-based approach. And I think that the similarity approach is really important and, in fact, indispensable to the animal rights movement, but over-reliance on it can lead to an impoverishment of our analysis. Over-reliance, it can result in an impoverished vocabulary and an inability to sort of critique and propose solutions to particular forms of violence inflicted on animals. Okay, part 2, language and epistemic injustice. And unfortunately, Ava, in her talk yesterday, is really going to take the thunder out of the sails of this section because it's basically identical to what she said. But in case anyone missed her talk or forgot what she said, I'll repeat it for you. Okay, so why might we think that it matters that we lack an appropriate language to describe unique forms of wrong experienced by animals? And I think we can answer this by reference to Miranda Fricker's notion of epistemic injustice. And just to repeat, epistemic injustice refers to a wrong done to someone as a knower or transmitter of knowledge. And it arises out of unjustified prejudice that exists both at an individual level and in society's political, legal, and economic arrangements. And as Eva noted, Fricker identifies these two forms of epistemic injustice: testimonial and hermeneutical. Testimonial injustice refers to instances where somebody's testimony isn't given credibility or isn't heard at all on the basis of the prejudice of the listener. And I'm not really going to talk much about that one, and Ava's already mentioned it, but what I want to focus on here is the second form of epistemic injustice, hermeneutical injustice. And this is about lacking the concepts to adequately understand or communicate an experience. Again, as Ava noted, the famous example given by Fricker relates to what we now call sexual harassment. So prior to the 1970s, this concept didn't exist. And so this meant that, for example, unwanted sexual propositions in, say, the workplace were were often treated as trivial or harmless or dismissed as flirting. And a result of this really was that victims of this behavior, predominantly women, of course, lacked a concept of sexual harassment and therefore had difficulty adequately articulating and perhaps even understanding what they were experiencing. Now, although animals themselves are probably incapable of articulating, or at least in human cognitivist terms, the nature of the injustices they experience, this is something that advocates for animals strive to do on their behalf. And this task is made more difficult when we lack the vocabulary to capture the nature of these harms. And I think that much of the current language doesn't really do the job. Now, of course, when it comes to describing something like so-called factory farming, we can, reel off a laundry list of the various, harms such as mutilations and confinement and slaughter, and living in animals forced to live in their own feces and not exhibit any of their natural behaviours. But of course, it's very cumbersome to have to give a laundry list of instances every time you want to describe something. And so what we do instead is try to come up with a term or a concept or a label that act as an umbrella to describe those collective set of instances. And I think that the terms, standardly used aren't particularly up to the job, right? So throughout this talk so far, I've been talking about factory farming, industrial exploitation, but I find myself not feeling very compelled by these terms. They don't really grab me. And I think in a sense they're almost euphemistic, because what we're talking about really, I think, is systematic torture. And I think perhaps the term that exists that most closely captures what I think about when it comes to these practices is the German word Qualzucht. Did I get that remotely correct? Good. Which is standardly translated into English as torture breeding. And currently I think this term has quite limited legal and social use in the Germanic countries and is primarily used to describe extreme forms of pure breeding of dogs. But I think as a concept it has quite far-reaching descriptive power for the sort of routine practices involved in the animal exploitation industries. And it does actually strike me as entirely accurate to describe so-called factory farming as a system of torture breeding and torture farming. Malnatalism might be another way of capturing this practice. Okay, part 3, the law, language, and thick ethical concepts. Now, this takes me to the issue of the law. The law is, of course, a language, and more than that, it's a language populated by what the philosopher Bernard Williams calls thick ethical concepts. Now, thick ethical concepts are concepts that straddle the descriptive and normative worlds. So purely descriptive concepts describe how the world is, whereas normative notions like right and wrong describe how it ought to be. And thick ethical concepts tend to contain both of these elements kind of wrapped up into a single term. So think about virtues, for example, like bravery or courage or kindness, or conversely, vices like cowardice or greed or arrogance. Now, these concepts describe patterns of behavior and characteristics that exist in the world, but they cast moral valences over them such that they are regarded as desirable or undesirable or good or bad. And I think that the law, as a system of rights and powers and obligations, is really unsurprisingly full of such thick ethical concepts. And I think we see this most strongly in the context of laws around prohibitions, so civil or criminal prohibitions. So think about offences like murder or assault or robbery, for example. Now, these are all pro tanto wrongs, but also descriptions of conduct. And I think that such prohibitions, don't merely place legal limitations on what individuals can do, but they also name and censure certain forms of conduct and redefine society's moral boundaries. And I think they therefore act as, or they serve the potential of being tools against hermeneutical injustice. And just to give a further illustration of this, consider, for example, the international crimes of genocide and crimes against humanity that enter into the legal lexicon in the aftermath of the Second World War. So genocide was coined by the Polish jurist Raphael Lemkin to capture the unique wrong of not only killing members of a group, but also to describe the wider processes of systematic discrimination, exclusion and extermination. Similarly, the term crime against humanity was popularized by Hirsch Lauterpacht to capture the universal and not merely provisional or local nature of war crimes. And I think one doesn't really have to think too hard about the cultural and political resonance that such terms have had. And indeed, I think it's quite hard for individuals born after the Second World War to imagine an ethical and legal order devoid of the notion of genocide, right? And despite ongoing controversy around the concept, it's widely regarded as one of the supreme international crimes. And likewise, I think it's hard for us to imagine a world in which the notion of sexual harassment doesn't exist. And I think this really shows the power of thick ethical concepts and legal prohibitions for shaping our understanding and moral sensibilities about the world. Okay, final part, problems. Now, I think that the examples of sexual harassment and genocide and crimes against humanity show us how powerful legal prohibitions can be in redressing hermeneutical injustice. However, the relationship between legal reforms and ethical norms is a complex one. Right? Does the law have the power or the potential to shape people's perceptions of right or wrong, or does it merely react to pre-existing concerns? I think this is a tricky chicken and egg question. Presumably there's a level of bidirectionality going on. So in England, for example, we know that the prohibitions on drink driving and smoking in public are widely regarded as having helped to contribute to social attitudes towards those practices that view them as kind of antisocial at the least. However, where ethical and legal norms lack widespread legitimacy, they don't tend to stick. We can think about, the prohibition of alcohol in the United States, for example. And for concepts such as sexual harassment to come into existence, this really required the work of the women's rights and feminist movements of the 1970s and the influence that they had. And of course, genocide and crimes against humanity could only come into existence as a result of a particular configuration of geopolitical factors, such as the Allied defeat over the Axis powers, the creation of the United Nations, and kind of widespread horror about the Nazi Holocaust, for example. And so this presents a problem, I think, for the animal rights movement, because currently the majority of the world's population kind of consume animal products, for example, and there are huge vested economic interests in maintaining the status quo. And this might suggest that efforts to change both the language we use in relation to animals and the legal norms in relation to them really can't be aligned with radical visions advanced by animal rights movement. So it seems that the prospects for this sort of radical shift look challenging, but maybe not so much as we think, right? So a recent YouGov poll in England found that 43% of the British public view animal lives as equal to or more worth than human lives. There's also a poll from 2017 that found that 47% of Americans, i.e. nearly half, support a ban on factory farming and slaughterhouses. And there are other polls that kind of can be cited that show a similar sentiment. And obviously there's a gap here between people's stated views and their practices. But perhaps this gap isn't just cognitive dissonance, but maybe it just shows that people struggle to live in accordance with the values that they hold. And perhaps one thing that could really tip the scales here would be technological developments, such as the development of very sophisticated synthetic meats or lab-grown meats. And if these become realistic, affordable, and widely available enough, perhaps they could start to replace animal farming. And as more people switch to animal-free products, they might start developing a practical and not merely a theoretical opposition to animal farming, and we can expect that opposition to grow. And these new material conditions could form the basis for a new form of mass consciousness about our relationship with the other species. And I think in this context, new concepts to capture the unique wrongs experienced by animals could help to crystallize this new form of consciousness and provide the basis for future prohibitions against such practices. So just to sum up then, this possible alternative legal order is going to need theorization, and I think a critical part of that theorization it will involve not merely assimilating the animal experience to the human experience and the human rights paradigm, but also to reckon with the unique wrongs experienced by animals and how best to identify them and suppress them. Thanks.